In this video, I'm going to be giving you some updates regarding the immigration ban that is currently in place, and I'm going to talk about a few other options that you may have, including other non-immigrant visa categories that you can apply for. Hello everyone and welcome back to another video. If this is your first time here, go ahead and hit that red subscribe button so you can join the D'Angelo Law family as well. The first update I have for you is that on June 29th, President Trump signed an additional proclamation that was an amendment to the previous proclamation from June 22nd, and the purpose of this amendment is to further clarify who exactly is subject to the non-immigrant visa ban that applies to the H-1B, H-2B, J-1, L-1 and their dependents. And basically what that amendment says is that if at the time of the effective date of that proclamation you did not have a valid visa in one of those non-immigrant classifications specifically, so you don't have a valid H-1B, H-2B, J-1, L-1 or any of their dependent classification visas, then the proclamation applies to you. To put it simply, no one in any of those visa classification categories, unless you're part of the exception group, but no one is able to obtain a new visa stamp at the embassy, whether you've previously held that visa classification or this is your first time obtaining that visa stamp. No one is able to obtain a visa stamp. So that means if you're here in the United States in that visa classification and you're looking to get an extension and obtain a new visa stamp at the embassy, you won't be allowed to do that either. So it's not just first-time visa applicants, it's also those that are looking to extend their visa stamps. So it's a complete stop essentially on issuing of any H-1B, H-2B, J-1, L-1, their dependents. The embassy is not doing any of those visa stamps for anyone looking to come in. And once again, if you're an exception to any of those categories, then you're fine. But if you're not, you don't fall under the exception, you are unable to obtain any of those visas. The next update that I want to give you is that the non-immigrant visa ban does not apply to Canadians who are visa exempt. So if you don't know, Canadian nationals who are in those visa categories aren't required to go to the embassy and actually get the visa stamp. They just have to present themselves at the port of entry to a CBP officer, provide proof of the validity of their petition, the validity of their classification, and then they will be allowed to enter and get an I-94. So because of that, certain Canadian nationals are not required to actually obtain the visa stamp, then they're exempt from this ban. So once again, what this proclamation is doing is saying that no one can actually get the visa stamp at the embassy for any of those classifications. So that's why Canadian nationals are exempt. The next update I have for you is regarding the K-1 visas. How the proclamations are written, the one from April 22nd and the one from June 22nd, both proclamations as they are written do not apply to K-1 visas, okay? So K-1 visas are non-immigrant visas. So they aren't subject to the April 22nd proclamation that was extended, because when you enter under a K-1, you're not entering as a permanent resident immediately. You're entering in a non-immigrant visa category, so it doesn't apply to you. And as for the June 22nd proclamation, it's specifically targeting H-1B, H-2B, J-1, and L-1 and their dependents. So once again, K-1 is not subject to that proclamation either. However, there are some embassies that are incorrectly interpreting the original April 22nd proclamation to include a ban against K-1 visa holders. I find this to be completely incorrect application of that proclamation and interpretation of what the order actually says. So keep that in mind. Some embassies are obviously applying the proclamation correctly and not prohibiting K-1 visa stamps. However, there are other embassies that are stopping the issuance of K-1 visas. So definitely check with the embassy that you are supposed to be attending your interview at and receiving your visa from them, because they might be one of those embassies that are incorrectly stopping the K-1 visa stamps. The next update I have for you is that the White House's website actually has a fact sheet published, And in that fact sheet, it talks about how the Trump administration is looking to reform our current immigration system to move towards merit-based. And what they're saying is this is in order to prioritize the highest skilled workers and protect American jobs. I'm going to very quickly read those bullet points here just so you have an idea of what they're saying. So, at President Trump's direction, the Trump administration is taking action to reform our H-1B immigration program. Under these reforms, the H-1B program will prioritize those workers who are offered the highest wage, ensuring that the highest skilled applicants are admitted. The Trump administration will also close loopholes that have allowed employers in the United States to replace American workers with low-cost foreign labor. These reforms will help protect the wages of American workers and ensure that foreign labor entering our country is high-skilled and does not undercut the United States labor market. I have several issues with these bullet points. It is my professional opinion that our current immigration system already does this, right? So even the PERM process, the H-1B process, is ensuring that employers are not hiring low-cost foreign workers to fill these positions. That is why there's something called the prevailing wage. As a requirement for the H-1B petition, the employer has to prove that they are paying the prevailing wage, the average wage for that occupation. You already have to submit an LCA to the Department of Labor that certifies the minimum wage that the employer must offer to the foreign worker. And with the PERM specifically, you have to pay them the prevailing wage, and you have to test the labor market and make sure that there's no available US workers. That's already being done. Even now, PERMs are going to be much harder naturally because there are more workers entering the market due to the high unemployment rate. So the PERM process is already protecting American jobs by forcing employers to test the labor market, submit, that ETA form to the Department of Labor, find the prevailing wage, advertise the position, so on and so forth. So why is there a quote-unquote need for reform? I feel as though the announcement of moving to a merit-based system is sort of like a political strategy due to it being an election year, because the process, the system in place is already doing that. It's already ensuring that employers are not hiring low-cost foreign labor. So I guess the update there is we will just have to see what reforms are going to be implemented with respect to the H-1B program. Okay, let's now talk about what options you may have now that there's a immigration ban that is currently in place until the end of the year. Here's the option if you are currently inside the United States. If you are currently inside the United States, do not leave. If you are eligible to extend your status from within the United States or change your status from within the United States and go through that process, then do that. Do not leave the United States and try to obtain a new visa classification, a new visa stamp at the embassy abroad. One, the embassies aren't open and it's very difficult to receive an emergency visa appointment. Trying to stay away from the traveling internationally to get a new visa stamp, definitely try to stay away from that route. Also, as I mentioned, it seems like the embassies may have their own interpretation of the proclamation, so you don't want to get caught outside of the United States, or your dependent gets caught outside of the United States because the officer at the embassy determines in their discretion that the applicant doesn't qualify for an exception, so on and so forth. You're really risking your entry back into the United States if you choose to depart and attend an interview at the embassy at this point. So the best option is to stay put here in the United States and do whatever extension application you can, change of status from within the United States that you can, if you are going to be obtaining a new visa classification, for example. So let's talk about the other non-immigrant visa classifications that are not subject to President Trump's proclamation, and this would apply to those within the United States or outside of the United States as well. Obviously, if you're outside of the United States, you have to wait for the embassies to reopen in order to get the visa stamp and come in. But if before the end of the year the embassies do reopen and start offering normal visa services, then you should keep these visa options in mind. So there is the O visa, which is for individuals of extraordinary ability. That's not subject to the proclamation. There's also P visas, which are for athletes, artists, and performers. The F1 student visa classification is not stopped at this time. So if you're going to study in the United States, the F visa is an option. M visas that are for vocational students, that also remains an option as well. You have E1 and E2, E1 treaty trader and E2 treaty investors. Obviously, if you have citizenship of a country that is part of the treaty with the United States that will allow you to get the E1 or E2 classification, then definitely look into that. Also, TN visas still remain available. Those are for the NAFTA professionals. If you're a Mexican citizen or Canadian citizen, then TN visas are still available at this time. Also, there's the H3 trainee visa that is not impacted by the proclamation as well. And also there is the E3 visa for Australian citizens who are entering to hold a specialty occupation. I do want to specifically touch on something regarding E3 visas. When you file the I-129 to obtain E3 classification, premium processing is not available, and you must wait for your I-129 petition to be approved before you can start working for your new US employer. If you're obtaining it for the first time or even changing employers, your I-129 must be approved first, then you can start working for them. And as I said, there's no premium processing available, so keep that in mind with respect to timing. But if the embassies are open, then that is a better option. But I do recommend staying put within the United States and doing whatever you can to stay here and not travel internationally, because you don't know if a new proclamation will be issued once you're outside of the country, so on and so forth. Those are other non-immigrant visa options that are still available that have not been impacted by the president's proclamation. Definitely confer with an attorney to see if you qualify for any of those visa categories. So I just wanted to bring those visa options to your attention. That way you don't lose all hope. With respect to coming to the United States, there still are options available. But once again, definitely speak with an attorney regarding your options. If you're inside the United States, how you should extend or change your status, or if you're outside of the United States, which visa category would you be eligible for and can obtain at the embassy once the embassies reopen. As new updates arise and more information comes out regarding the proclamations, I will definitely keep you informed and make future videos regarding that topic. So definitely make sure you are subscribed with your post notifications turned on so you can be notified the next time I have an update for you. Also, make sure to give this video a thumbs up so YouTube knows to spread it throughout the platform. Thank you for watching, and I'll see you in the next video.